The date was March 23, 1989. The oil tanker Exxon Valdez left the port in Valdez, Alaska, a little late, loaded with 53 million gallons of crude oil. The captain, Joseph Hazelwood, a relapsed alcoholic, took the tanker out of the regular shipping lane to avoid ice, then told the third mate when to make the turn back into the lane. In a violation of rules, he then left the bridge, and a short time later, the Exxon Valdez hit Bligh Reef, spilling 11 million gallons of crude into Prince William Sound, and in the process, creating one of the worst environmental disasters in U.S. history. That was nearly 20 years ago, and since then, the company has paid $3.4 billion in cleanup costs, fines, and compensatory damages. And in 1994, a federal jury ordered the company to pay another $5 billion in punitive damages, a figure later reduced to $2.5 billion. Today, in arguments at the U.S. Supreme Court, the company's lawyers asked the justices to throw out that award, arguing it's excessive, not even permitted under maritime law. On the other side, lawyers for 32,000 Alaskans affected by the spill argued $2.5 billion was justified, given the damage done.
There's a lot more wrong than the oil that's on our beaches. And part of it is the justice system itself. The justice system is broken. What $2.5 billion is going to do is to help deter the next oil spill, and the one after that, and the one after that.
Exxon's lawyers did not speak after today's arguments, but their message appeared to resonate with some of the justices who suggested they might be inclined to reduce the award, as they have other recent high-profile punitive damage awards at the Supreme Court. Now, for more on today's arguments and this case, I'm joined by two lawyers involved in the case. David Frederick is an attorney at Kellogg Huber Hansen, representing the state of Alaska. Evan Tager is with Mayor Brown. He filed a brief in the case on behalf of the American Petroleum Institute. Thanks to both of you for being here. And Evan, let me begin with you, if I could. Why is $2.5 billion not the correct amount in this case?
Well, the question in any punitive damages case is how much is needed to punish and deter. And in this case, the conduct for which Exxon is being mulcted in punitive damages is essentially the equivalent of shooting itself in the foot. This was not a malicious act. It was not a profit-driven act. It was a big mistake. It was an accident. As you said, they've already paid $3.4 billion. They don't need a penny more to deter or punish them, from shooting themselves in the foot a second time.
David, your take on that? ExxonMobil has paid $3.4 billion. They say they're not going to do this sort of thing again.
Well, I think that punitive damages have to be looked at in terms of both deterrence and punishment. Here, the only amount paid by Exxon for punishment was a $25 million fine. They spent, indeed, billions of dollars to try to clean up the environment, but even the cleanup was inadequate. And each of the plaintiffs in this case received in compensatory damages about $15,000. The punitive damages would increase that amount to about $75,000. And this was a spill that destroyed their lives, wiped out the economic livelihoods of villages, and ruined the fishing industry for many, many years. $2.5 billion is 3 weeks of profits for Exxon, hardly an amount that would deter action if the company doesn't sit up and take this seriously. And let me add that after the verdict came in, the only person who suffered any adverse employment consequence was Captain Hazelwood himself. The people who supervised him, who knew that he was a relapsed alcoholic, who knew that he had been drinking for 3 years after his alcohol program, and who nonetheless put him in charge of the Exxon Valdez, got promoted. That's not exactly deterrence.
Evan, how about that Exxon's conduct in terms of just handling Mr. Hazelwood and his situation, plus the sheer size and scope of this disaster, the fact that Alaskans are still dealing with it today, merits this kind of punishment?
No, because first of all, there's no way to know what the jury actually found in this case. The jury was instructed that it could hold Exxon liable for punitive damages based on the recklessness of Hazelwood himself. So this is their theory of the case, but we don't have a jury finding to say that Exxon actually knew that he was a relapsed alcoholic. But even if he was, there's no reason to think, having suffered all of these consequences already, that they would ever allow anyone like him near a tanker again. They made a big mistake at the time. At the time, the thinking was that you didn't want to deter people from self-reporting if they had substance abuse problems. So you didn't fire them, you didn't demote them, you treated them, and then you allowed them to retain their positions. So in a way, what you're doing here, if you're going to pile all this punitive damages onto a make-whole compensatory award, is simply over-deter and cause companies to basically fire everybody who they suspect of having a substance abuse problem, which will then possibly result in people just keeping it under wraps.
They didn't have to fire Captain Hazelwood. They just didn't have to put him in charge of a supertanker. And that's the key point here, that Exxon's CEO, within weeks after the spill, said on Face the Nation he was drunk. It was a gross error on our part to put him in charge of the supertanker. It's revisionist history to now say that the jury would not have found, after all the Phase 3 evidence was in, of the multiple dozens and dozens of reports of Hazelwood's relapsed alcoholism, and Exxon supervisors did nothing about that.
Well, let me ask you both. You were both in the courtroom today. We heard the justices respond to some of these arguments. Evan, let me get your take on it. There were some indications today that justices sounded open to the idea, if nothing else, knocking this figure down.
Yes, it did appear that a number of the justices were concerned with the size of the award in this case, and generally with the increasing size of punitive damages in other cases. And this is an opportunity for the court to set some tighter standards for the imposition of punitive damages. And we saw today not only a discussion of can there be a sort of maximum ratio of punitive to compensatory damages, but also what kind of factors should courts consider. And we heard talk about, well, you have to look at what's the nature of the conduct. Here, it clearly was non-malicious, non-intentional, non-profit motivated. You look at whether there are other deterrents, like the compensatory damages, like the reputational harm.
Let me get David in here. Did you read the justices the same way? And are there wider implications here for punitive damage awards in the future from this case?
Well, I would say that the justices did what they typically do, which is to explore both sides of the case vigorously and aggressively. I thought the questions were penetrating. The justices were very well prepared. It is true they floated a couple of ideas, individual justices did, on how they could reduce a punitive damage award, while at the same time accepting the reprehensibility of Exxon's conduct. Now, with respect to the effects on other cases, I think it's invariable that a Supreme Court decision in a landmark case like this will have other effects.
All right, David Frederick, Evan Tager, thanks to both of you for joining us here. We're back after a short break here on Money and Politics. Take a look at a decision affecting Fannie Mae and Freddie Mac.